Handle Your Business, a weekly podcast discussing a little of this and a little of that. Handle Your Business appropriately blends serious topics with fun topics, all in an effort to help you have a good or better life. So join me, your host, Lady Lashley, and some amazing guests every Sunday at 5 p.m. to explore everything from financial management to dealing with relationship challenges. Put it in your calendar every Sunday from 5 p.m. Tune in to Handle Your Business to get you ready for the week ahead. For more details, follow at Lady Lashley TT on Instagram and Facebook. Handle Your Business. Welcome to another episode of Handle Your Business with yours truly, Lady Lashley. Today I have with me attorney at law, Kern Edwards, and we are going to be discussing wills, the thing that many people don't like to talk about, but it's very, very important to consider. Hi, Kern. Thank you for joining me.
Hi, good evening, Glendora. It's nice to be with you this evening.
All right, lovely. So, Kern, you're going to be our key expert or key specialist this afternoon because wills are usually considered a kind of legal thing. However, very recently, I was reminded that it doesn't have to be. So, my first question to you will be, can you explain what exactly a will is?
I'm not sure what told you that it's not, but wills are legal documents, right? Mm-hmm. Essentially, when you have a will, it's a document by which you are giving your expression of the things that you wish to happen upon your death. So that document by its nature is one that is only effective upon someone's death. It doesn't have any effect while the person is alive. By it is where you give all the ideas of the things that you want to happen. Most times it's used for disposing of property, the things that you own, for appointing someone to be responsible for dealing with your property when you're gone. But it is a legal document. The law prescribes particular ways for it to be created. And in our country, it has to be written. So you can't have an oral will, for example, right?
Oh.
So a will is a legal document. You'll tell me as we go along where you got the non-legal version from.
So not to put anybody in trouble, let me just say I probably read something that said that you didn't have to have quote unquote an official will, but if you were home in your house and you had a notebook or a piece of paper, you can write down. I did read that it had to be written, but you can write down what you want.
Terminology will become important with a lot of the aspects of dealing with wills. You use another word there, and I thought official. What do you mean by official, right? But there are terms there. So if you're thinking in the sense of professional, in the sense of having it be drafted by someone whose expertise is in drafting wills, as opposed to someone who's doing it who doesn't have that expertise, then you'd be correct in that you don't have to use a professional to make a will. You could sit down and put together your will for yourself without going to someone who is a professional. So maybe that's the distinction that you're drawing there.
Yes. You see how it's so important to pay attention to words and language and meaning, especially when you're dealing with legal things. As people like me who is just be saying things that I know what I mean, it might not necessarily be legally sensible. All right.
No, it may have different meanings. It's certainly the case. And with wills in particular, terminology is really important. In our country, we don't have, the legislation doesn't prescribe a distinction between a professionally drawn up will and a non-professionally drawn up will. What you find is that when we come to interpret the documents, we usually apply the same standards, right? In some of the other countries in the English-speaking world, they do draw that distinction. So if a professional drafts a will, it will be interpreted in a particular manner in terms of how literal we put meanings to words. Whereas if a non-professional were to prepare it, we'll interpret it in a slightly different manner, right? But we don't have that in our country as yet. We interpret all wills presently in largely the same way.
Okay. Now, one interesting thing that you said in terms of it must be written. You can't have oral instruction to say,
No,
"Hey, now when I dead, give the house to so and so."
to this person, right?
Why
No.
must it be written?
Well, our legislation prescribes that as one of the first requirements for making a will. So for a document to be considered a will, it must be in writing, right? So that's not an option. So if it is someone tells you they have a will and they say, well, this is what the person said, and it's not written down on a document, well, then that will not be considered a will. It must be in writing.
Has there
Right?
been any sort of move to, now that we're in the age of technology, because that law may have been written in the olden days according to one of those
Yeah,
people.
yes, it was done in the olden days.
Right. So if I make a
It was
video, I sit down and I make a video and say, I want to leave this
presently
to so and so.
our legislation doesn't contemplate that you can do that, right? I know in some of the other English-speaking countries, there are some movements towards doing it, but you more get it, say, in the United States of America than in other commonwealth countries. So if you're in the United Kingdom, Canada, Australia, the Caribbean, wills are usually required to be done by writing. So at present, no, you can't do a video for your will, at least not in Trinidad and Tobago.
All right.
It must be in writing.
Fair enough. Are there different types of wills?
For most people's purposes, the answer would be no. But yes, there are different kinds of wills, but the different kinds aren't typically what you and I may think of as a will, right? So there are kinds of wills that may be created because of these circumstances. Like say people who are soldiers, for example, at war, and they do wills, right? Those particular wills are treated in a particular manner, right? Sometimes as well, you may create a will, but it's dependent on a condition occurring, right? Those kinds of wills are not the typical wills. So the general idea of what you may think a will is a document by which you are expressing the things that you wish to occur when you die. That's what a will is. The different forms, like the ones that I just gave you, those two examples, those are not very common.
Okay.
Right?
I know this may sound stupid, but I'm going to ask you anyhow.
No, there's nothing stupid in law.
Well, this is the local.
Go ahead.
Is a will necessary?
That's a yes, no, and it depends question, right? Mm-hmm. So I described what is the purpose of a will. It's meant to express what you wish to occur when you die. But there's no requirement to make a will. Throughout the world, not just in Trinidad and Tobago, lots of people die without making a will, right? If you were to die without making a will, we have rules that will govern what becomes of the things that you leave behind. So under that state is what we call dying intestate. So when you die intestate, it means that you didn't make a will. If you die testate, that's when you've made one. So when you die intestate, we have rules, and those rules prescribe who will get the things that you leave behind. So in Trinidad and Tobago, the first persons who will receive anything out of what you leave behind would be your spouse and children. If you have a spouse alone, well, your spouse will get everything. If you have no spouse and you have children alone, then your children will get everything. If you have both, then it will be shared between the spouse and the children, and it prescribes the proportion.
Sorry to interrupt you. Spouse and children, is in this case, is spouse also considered to be a common law spouse, or you must be legally married?
Right. So that's a special reason why you must make wills, right? We'll come to that. But depending on the context, spouse here means someone that you're married to, right? But in a scenario where you, and this happens in our country and lots of other places in the Caribbean, some people may have a married spouse, one that you have a marriage certificate for, and you have the common law spouse too, right? That does tend to happen sometimes. Right? Or you might not be married at all, but you're living with the person. right? What it does do, our legislation prescribes what that common law person would have to do to become entitled. They are not automatic. So that's one of the distinctions between being married and being not married. In the sharing between spouse and children, if you are married, meaning you have a marriage certificate, you are automatically going to be entitled under the laws of intestacy. But if it is you're not married and you were living with that person, you can become entitled, but it's not automatic. Common law spouses are not automatically entitled, whereas a married spouse is. So if you are in a common law relationship and your partner dies without making a will, you will not automatically share in what that person has left behind. You can become entitled, but it forces you to go through a procedure to get through with that entitlement. It requires you to file notices with the registry. Then you have to start court proceedings to have the court confirm that you were in a relationship with the person who died. And it's only when you go through those court proceedings, the court will then rule as to whether or not you had that relationship. If they agree that you did, they will then go on to state, well, how much of what he left behind you be entitled to. What you find in scenarios where the person doesn't have a married spouse as well, they often will treat the common law spouse in the same manner as if you were married. That's the typical ruling when they say how much you are entitled to. Right. But it's not automatic, right? So you're forced to do court proceedings, whereas if you're married, you don't have to do any of that.
No, hold up, eh? I think you're going to need to maybe give me a whole lot of time in there because you just raised a bacchanal question in my mind.
What is your bacchanal?
I get this part with if you have a unmarried common law spouse, that person, what they're going through and so on. But the bacchanal question, if you are legally married, but you still have a next one. Yes. So what going on there?
Both persons will likely become entitled to share in what you left behind. What would happen for the common law spouse, because they are forced to do court proceedings, in those court proceedings, the court will then have to identify what they will be entitled to. So what you find happens sometimes, if you, as the person who has died, have acquired different properties, and some of those properties were acquired after you began your relationship with your common law partner, most times those would be the kinds of assets that that partner may share in, right? If you have items from, say, while you were married, then more than likely your married wife would share in those assets and not in the assets acquired after. Right, so it can become ticklish, but you know, our discussion here is on making wills. So that example that you give there is a good example of why you should make a will.
Well, you know what, too, Kern? You even pushed my mind into more bacchanal, because that one is still simple in the sense that yes, you're married, separated, and you have a new partner that's common law. What about them who married, living with their married partner, but they still have an ex-partner somewhere that they're spending a lot of time by and maybe sharing children with? So you have like simultaneous relationships, and you're not under like Islamic rights or anything. We're talking regular, normal people.
But you see, the married wife will always start at an advantage because the laws of intestacy recognize you as being the wife, right? All the other relationships are not going to be automatically recognized. They are forced to do court proceedings to have their relationships with you defined, right? So not everybody, let's say in that scenario where the person dies and they have two other partners, right? So this one person dies and they have three partners. So the married partner is automatically entitled, doesn't have to do anything extra. But the other two unmarried ones have to do court proceedings so that the court can say, did you have a relationship with this deceased person or not, right? Chances are when you have more than one relationship, it might be harder for some of them to say yes, right? One of the requirements for the court to confirm your relationship, you have to have been living with the person for a period of at least 5 years before they died, right? So if you are spending your time between three different partners it's going to be hard for the other two to show, well, hey, you were definitely living with me as husband and wife up to when you died.
How many days you have to be sleeping there for it to be considered living with?
But that's the thing, it becomes difficult, right? Let's say you share children with both partners. That by itself is not going to be enough. It will have to be that you and I are going out and about as husband and wife. Right? So you see where the unmarried person has that difficulty.
What
right?
I'm seeing, Mr. Lawyer, is that all heap of people in the Caribbean need to have wills.
Yes, yes. But there's another aspect to your example as well, right? If it is you are in a married, if you are in a relationship with someone who you're not married to, while still married to someone, then you should get divorced from the one that you are married to, and then perhaps marry the one who you're actually living with, right? So in much the same way we have the tenacity for let's make wills, and the scenarios are telling us, hey, let's go about making wills. Another aspect in here is get divorced, right?
But some people don't want to be married again.
Well,
they might want the relationship,
right,
but they don't want to go through the whole process.
You do wish to be married again, but don't stay married to someone who you're not living with, right? So get divorced, right? So, but it leads into the making of the will. So in this scenario, you have 3 women, 3 men, as the case may be, and you have more than one partner, make a will. So that way you are able to define what you wish to happen for each of those persons and not force them to have to do court proceedings to determine what they should get and what they shouldn't get, right? If you make a will and say, well, hey, I have wife number 1, this is what I leave in for wife number 1. I have wife number 2, this is what I leave in for wife number 2. I have wife number 3, this is what I leave in for wife number 3. Same if it were the reverse. If you have husband number 1, this is what I leave in for husband number 1. I have husband number 2, this is what I leave in for him. Husband number 3, well, this is what you will get, as the case may be, right? It's a good example of why you should make your will. So in a scenario like that, it's a requirement that, hey, you can sort out your affairs by making a will.
Now, right? Before we jump into the whole process and procedure of making a will, one other thing for clarity, you said when the person dies, and it's time for consideration. Let's say you die without the will.
Yes.
The children and the spouses, legally married spouses, sometimes the common law spouse, they automatically considered. Is there like an automatic thing to say, well, the wife gets more, the children get more? Is there like what does the law share?
Yes, it is defined, right? So currently the shares between the spouse and children, if you have both, the spouse is entitled to half of what you leave behind, and the children are entitled to the other half equally. So if you had one child, that one child will get the entire second half. But if you have 2, they will split it between themselves, right? So let's say you left $100 behind. Your spouse will get 50. Your child, if you only had 1, will get 50. If you have 2, well, each child gets 25, and so on. So you break it into that fraction that represents how many children you have, and they will share the other half.
Right. You're putting a lot of things into my head here, because like for those people who, let's say, maybe not in good relationships, some people is divorcing their mind, but they're still living with the person and so on. If you want to leave more things for your children, you need to make a will.
A will, yes, certainly. Right? Because but there's another example. So we use the example of the common law. But what about when children are not your children? Right? So let's say in that example of having the 2 relationships. So you're married, and then you pick up with this next person and you're living in the common law relationship with them. But that next person has children too, right? And you largely raise that person's children as your children, in addition to having children with that person. So the stepchildren are not going to be entitled, right? It would only be your biological children.
You have to make special provisions for the stepchildren.
You have to make a will. That's the only way you'd be able to leave something for them, right? If you had adopted them, well, that'll be different, right? Because they will then be treated as being your children. And this is adoption in the formal sense. They're not saying, well, telling everybody, this is my child, but I have no
Yeah.
documents
Me
to,
raise
to
him like
show
a
it.
me own since he's small.
Right? No, no. You actually have to have done adoption proceedings and gotten an adoption order.
Yeah,
And
through
the
the
child will
court.
then be treated as being your child. You'll not need to call them adopted, right? But if you don't do that process, then they're not going to be entitled, right? So that's a good reason to make your will. So you could then leave for all your non-biological children,
That's
right?
amazing. That is amazing, amazing, amazing. And I suppose later on I'll want to ask you, or we might have to do a part two on wills, because I'd want to ask you about, who could contest the will. Sometimes you leave out how you want and somebody feel, well, this person shouldn't get that or whatever, and they're trying to go to
Yes,
court. Or
well,
maybe that's just TV thing.
no, it's not. You can contest wills. I mean, we haven't gotten into all the details behind wills, but there are different areas that will lead to a will being challenged, right? Consider one of the simpler ones. Person was losing their mind, right? Particularly with older people, they start to lose their memory and they're not able to remember as much, or they may come and go, as we would say. If someone is losing their mind and a will shows up during the time that they're losing their mind, is that going to be a valid will, right? So your mental capacity is an important aspect to making wills. So if you are losing your mind and a will shows up during that time, that would be a ground on which someone may choose to challenge the document and say, well, this was not a valid will. This testatrix was losing their mental faculties, right? So there are lots of aspects of how you can challenge with. So that's one challenge. And again, I was mentioning that there are lots of terminology in here, right?
Right.
There's another procedure that allows you to challenge a will, but challenge is the wrong word here, right? If it is you mentioned in your example, leaving somebody out, right? A person who is left out doesn't necessarily need to challenge the will in the sense of saying it's not valid. They may accept it as being valid. You were in your right mind when you left me out of the document, right? But having left me out of the document, I am then entitled to challenge the gifts that you've made in the will. So that's a different kind of challenge. So you have the challenge where you're saying this is not a will at all. But then you have another challenge saying that the gifts that you've done in this will haven't made any kind of provision for me. So in our country, you have Trinidad and Tobago and some of the other Caribbean islands as well. You have a particular freedom to make your will, to put whatever you wish into your will. But if you leave out certain categories of persons, those persons can challenge the kinds of gifts that you have left for them. Sometimes
Hold
you're
up.
not even...
Hold up. So you're telling me I make my will, right?
Yes.
One of the children that I have, I can't stand them, right? Or
Yes.
some kind of thing, or they behave bad or whatever, And I
Yes.
decide I ain't leaving nothing for them. I
Yes.
make the will and I put this one. For that will not to be contested / challenged or whatever, I had to write in a line to say, I deliberately leave nothing for so and so.
Yes, and you can. You certainly can, right? Let's put to that example. So that child that you leave out, you say that child treat me so badly while he was around, I am not leaving anything for him. You put a line of it into the
Okay.
will,
But do you need to
right?
give an explanation, or you could just say, I am not leaving anything for so and so. This is my
Well, if you are having your will professionally prepared, most professional drafters will put in the reason that you give. Because it's the one way that you'll be able to speak after you're gone.
Okay.
To say, well, hey, I left out this person because, right? Let's use the multiple husband and wives example again. If you, and as I said, get divorced if you're not living with your married wife anymore. But if you are one of those who dies still married to the person, never divorce them. You may make a will and say, well, hey, I've not left anything for my wife because she and I have been separated for 20 years, right? That's a perfectly legitimate reason
Right, gotcha.
within your document, right? So it's not unusual to put that into your will, because you can then give that example, right? But the child example is interesting, because while it is the child may be able to question not receiving a gift, the child is less likely if it's an adult child, right? We'll distinguish an adult child from a child who's underage or a child who may be disabled or mentally challenged, right? An adult child with no other difficulties would have a harder time challenging being left out of a will.
Right.
Right? It's not that they can't be left out or that they can't challenge, but they'll have a harder time showing that they didn't get anything and the person ought to have made provision for them. Right?
Because after all, you're an adult.
Well, I mean, that's only part of it, right? I mean, some people, let's say, for example, you are in university, so you're still in your first 2 or 3 years of studying, as the case may be, and your parent has left you out. They think you are an ill-disciplined person. They leave nothing for you in the will. So you are an adult, but you may still be largely dependent on your parents, right? So a child in that scenario might have a slightly better chance of saying that, proper disposition wasn't made for me, as opposed to someone who had already been working, might have their own home, family, that sort of thing, and has been left out. They may have a harder time to challenge the gifts where they have not been given anything or they've not been given as much as others. Right? So that's a double-sided challenge. So you can have the challenges that go to whether the will is a valid will or not, and then you can have the challenges that go to the kinds of gifts that are made in the will. Right?
We need a part two, that's plenty.
No problem.
That's plenty.
One of the things with making wills, even though you and I trying to have this brief discussion about it, there are lots of textbooks that are written on this topic, right? I couldn't possibly read the whole textbook for you if I tried. Right, so there are lots and lots of areas in making of wills, but it's important. I as a legal professional will always tell you, go to lawyers to have your wills made. But as we started off, and I told you, you're under no obligation to do that. You can make your will for yourself once you follow the requirements of making a will. Let me tell you some of the general requirements for making the will. So we touched on one. The first one is that it must be in writing. So the second part of it must be signed in a particular manner, right? So it must be executed, as we would call it, in a particular manner. So it must be signed by the person making the will. So let's just give some names to some different things, right? So the person making the will is called the testator. If the person is female, it's testatrix. You'll have witnesses, you'll have gifts, you'll have beneficiaries. Right? Those are some of the words that you'll hear as we go along, right? So when you are doing execution, the testator has to sign the will in the presence of 2 witnesses in Trinidad and Tobago.
Seriously?
Yes. So if you prepare your will at home and you didn't go to the lawyer and you only bring 1 witness, then your will not be a valid will, because you must have 2 witnesses, right?
So all them old people who write down on a piece of paper just before they die, or they know they feel sick 2 weeks in advance and they write down.
Yes, and nobody you write down your wishes, and nobody can see that you write down your wishes, then it's not going to be treated as a will for our purposes.
Oh boy.
Right? A will must have 2 witnesses. You could have more than 2, but I mean that's not common, but you can't have 1. And you certainly can't have none. Right? Wow. So you must have 2 witnesses. Two other requirements from the testator. The testator must be someone of age. So children cannot make wills, and people who have mental disabilities ordinarily cannot make wills as well. Right? So you must have your mental capacity. We'll come back to mental capacity after we do execution. So you must sign your will in the presence of the 2 witnesses. So those 2 witnesses must be present while you are signing. They must be in the same room. It can't be, I sign the document and then I call you and tell you, hey, come and look at this document and sign it for me. everybody must be in the room at the same time. So all three persons, the testator, the two witnesses. So when the testator signs first, that the two witnesses must be able to see that the testator signed the document. Then the two witnesses must also sign the will in the presence of each other and in the presence of the testator. So all three persons must sign together, and they must sign in the presence of each other. So testator signs first, witness one signs, witness two signs. All three persons must be in that same room seeing each other sign.
But how will the court know that they were in the same room?
Well, normally when it is you are doing the process after the person has died, which is probate, one of the requirements for getting probate is that one of those witnesses has to give an affidavit speaking to the execution of the will, to say that I was present on the 13th of January 2023 and I saw the testatrix sign this document. She signed this document in the presence of me and this second person, right? And then I signed the document in the presence of the testatrix and the second person. And the second person signed the document in my presence and in the presence of the testatrix. So that one of those witnesses will speak to it.
Wow. So before you die, you have to make sure them people are still alive.
Well,
because if they die, you die and they die.
No, you don't have to make sure that they are alive, but there are requirements that we use for scenarios where the witnesses may also have died apart from the testator, right? But ordinarily, what we advise is that have people as your witnesses who are not necessarily too old. In the case where you feel, well, if they're going to live, they'll still be around after I am gone.
You can't
right?
be too old and too sick.
Right? Neither, right? So if you, let's give a silly example. So if you're in the hospital and you think you're on your deathbed and you say, I want to make a will, you can't turn to the patient next to you and say, hey, sign my will for me, right? You wouldn't, because they might be in the exact same scenario as you, right? So, but I mean, you can never know when you're going to go. So that's not a way to determine. But generally, you try to have people who are younger than you, who you will expect will be around after you are likely to be gone, right? Mm-hmm. And you preferably want someone who might generally be in good health. So that's the general idea. But both witnesses and the testator must sign in each other's presence. So that's your second party requirement. Another aspect of the signing is that the will must be signed at its end, right? So you can't sign it at the top of the document, right? If the testator signs it at the top, it's not going to be treated as a valid will. It must be signed after you've said everything that you need to say. Is at the end is where you must sign it, right? The second aspect is where you get into the mental capacity. Mm-hmm. So that's the formalities in terms of how the document has to be done, right? It must be signed in that particular manner. You as the testator making the will must also have the mental capacity to do so, right? So if you are someone who is classified as being mentally challenged, let's say because you've been to the psychiatric hospital, or you might be a patient at the psychiatric hospital, you may not be someone who's treated as having the capacity to make a will, right? If you are someone who, not in the hospital, but you have those kinds of illnesses, it can often be questioned whether you have that capacity or not. If you are someone who is older and is starting to lose your mental faculties, it may often impact on how well we treat you in terms of being able to make a will. What you find we do with older persons in particular is we often ask them to get an assessment done by their physician as to what their mental health is like, what their physical health is like, right? So that when it is you are going to prepare a will for someone who is older, you can be satisfied that nothing is wrong with them. Sometimes you as a person will know for yourself. You'll see the person and you hear them speak and they can perfectly articulate what it is they want. So you may not do that. But as a general rule, for someone who is older, you tend to ask for that to be done before you begin the process of preparing the will.
Is there like a specific age group when you say someone who is older? Is it like how legally senior citizens are 65 and up, or it's just when you see them?
As a professional, depending when you see the person, you will make your decision based on what they tell you, right?
And how
There are
they
some
present.
persons who are older and they are perfectly fine. They speak perfectly fine. You can tell that they're losing any part of their faculties whatsoever, right? A really good example from the world. The Queen Elizabeth was 96 years old when she died. Whenever you heard her speak, you can tell that she was losing her mind, right? Nothing about her suggested that she had anything but full control of her faculties, right? Even at 96, right? But then you might meet someone who is 66, and when you hear them talk, you question yourself. It's like, what it is they talking about? Are they talking to me, or are they talking to the secretary, right? So you as a person preparing it would make that judgment based on the person who's before you, right? Normally, to prepare someone's will, they will come to you and they'll give you their instructions, the information that they wish to have put into this document. But if they can't articulate it properly, or they continuously questioning themselves or the things that they see, and they're not able to do it for themselves, or sometimes, as often happens, they bring somebody with them, and it's the person they bring with them that doing all the talking, right? So can you genuinely say that the person who's giving you the instructions there has control of their faculties, that they know what it is they've come to do, right? So you would make that assessment based on the person who comes to you, right? So mental capacity is an important aspect of making the will. So you must have mental capacity. So that's why, as we were mentioning earlier, if it comes to challenging, mental capacity often can be a reason why a will is challenged. If you say that this person didn't have their right mind at all, right, that would be a reason to challenge the will. It's like, how did this person sign this document when this person talks about rabbits and saying that this rabbit is so nice, but you know very well it's chicken that they're eating,
oh boy.
right? Right? So it's not rabbits. So that person likely is losing their faculties. So a person like that, any will that comes out while they have got to that, and one of the difficulties with mental health is that most times if you get into the point where you are degenerating, you're not likely to recover, right? I mean, I know there are a lot of drugs now that are being developed that are helping, but most times when you start to deteriorate, you're not going to get better.
The drugs just prolong a little bit.
And sometimes it gives you like little zaps so that you really sound like you're with us all the time, right? But if you are one of those who has started to leave us already, then any will that you do in that scenario is likely to be challenged as not being valid.
I know this is mental health in the aspect in terms of, we've mentioned that there's a sign-in requirement, there's a mental health requirement. What about physical health? You know, there are some people, let's say, they suffer a stroke, that kind of thing.
Right, physical is just as important, but again, it does depend, right? Stroke is a good example from the perspective that the person may have difficulties to communicate, right? It doesn't necessarily mean that their mind is gone, right? So if, for example, you can't physically move about, but your mouth could still go, you know that's how some of the older people get. They can't move about plenty, but you hear them out from wherever it is you are, right? So if you're able to judge that person based on how they speak, that will be fine. But if a person is also struggling to communicate that way, in the same way that I tell you, we get a doctor to have them assess. You assess both physical health too. Because if you are in poor physical health, that can also be a reason to challenge someone's will. In that, if I am sick, being sick doesn't mean you can't make wills, right? But if you are sick and the effects of your illness on you are such that it weighs down on your mind all the time, right? That sometimes may impact on the thinking that you have to be able to give instructions on what you want to do and how you want it to be done, right? You might not be able to think straight, as we sometimes say. You know, physical illness can cause that to you in much the same way. Right? So physical illness is not a requirement for making wills, but it can certainly be an aspect that is used to challenge if a will comes out, right? So anytime a will appears for somebody who is ill, right? So I came across an example recently where the person died and they're saying that the person made a will, but the person was suffering from stage 4 cancer, right? And had been in the hospital, had been hospitalized for a considerable period of time, had been discharged from the hospital to go for palliative care, right? Because they're expecting you to go, right? So in a scenario like that, that person's physical being might be weighing down their mental being. So that the will that they prepare in that scenario may not be what they would do if they weren't ill, right? But it's obviously a little harder to challenge as compared to the mental side, right? But it's just as important. So that's why, from a professional perspective, we get the doctors to do the assessments, right? Even for somebody whose mental capacity might be okay. For people who are ill, depending on what the illness is, you need to be satisfied that that illness is not weighing down on them, right? But physical health is by itself is not a requirement.
That's very interesting, and unfortunately, the time is going away on us. We have less than 10. Yes, we have less than 10 minutes here, so we definitely have to split this into two parts.
To do a part 2. Okay,
yeah, we have to split it into 2 parts. But just to recap so far in terms of some of the things that we touched, though. I mean, we start off about talking about what is the will. Yes, there are different types of will, but in our general context within, Trinidad and Tobago and the English-speaking Commonwealth, it might just be the whole simple idea of leaving your property,
for someone.
Assigning your property.
That's the main purpose for doing wills for most people.
In terms of who should consider getting a will, I mean, we have quite a few people.
Anybody can make a will, right?
Yes.
There's no requirement besides that you must be of age. Anyone can make a will at any stage, right? We've used examples earlier on of people particularly who should make wills, right?
Yes.
But there's no restriction on it whatsoever, right? Maybe in the part 2, I'll touch on some of the other aspects of why when you don't need to make a will. But I gave the example with the laws of intestacy. Some people don't make wills because they're comfortable with what the laws of intestacy are.
Yes.
Right?
You give the wife half and you split up the other half between any children.
Or you might only have children, you might already be divorced, and you say, well, my children will get everything, and they will get it equally. So you don't feel the need to make a will. So you could be satisfied with the terms of those laws, right? There are other aspects that you can do that are not wills. Some people, they don't wait to make a will. They give away what they have while they're here, right? So you are certainly entitled to do that. That's an alternative to making a will. Doing joint holdings of property. So if you have a joint account or you are joint tenants of a piece of land or something
the
like that,
other person automatically gets it.
Becomes the owner of it when one of you passes on. So that's an alternative to making will. Those have their disadvantages as well, right? Wills have their disadvantages too, right? But those are alternatives. So you, as the person who's considering your planning of your estate, you will decide what avenue is appropriate to you, right? But will certainly is one of the main avenues for dealing with what you leave behind, right? You have a particular way to make wills. You know what the requirements are. You must be of age. You must have it in writing. You must sign it in the presence of your witnesses. They must sign in your presence. You must have the mental capacity for making the will. Right, those are the basic requirements. We could touch on those alternatives in terms of alternatives to wills, or you can also touch on the kinds of challenges that will happen with wills going forward, and some of these things that you can put into your wills.
Right.
Just some general areas as well.
What we definitely going to do is make that into part 2. I like this wrap up right here. So we keep the people who listen to this podcast wanting more, because at the end of the day, this is handle your business, eh? So when they see they listen to this episode and they say,
please handle your business.
I'm telling you that lawyer on point. I don't go back for part 2. Listen, I actually learned quite a few things listening to you. See, when you think you know something and you really don't know, that's why they say check a professional, at least a good professional. Right?
Yes, and certainly I recommend that as well.
Yeah.
I mean, I know we did talk about making your homemade will and whatever, no. go by a lawyer and let them prepare
Well,
your will.
here now, you have me needing to call a lawyer now because I do well write down what I want to know. I buy a little book and thing and write down
But you
what I
only
want.
had one witness, right?
It had no witness, it's me alone. It's me alone. I can't even use. I can't use my daughter as a witness. She's underage.
No, you can't use her.
She's
right?
underage.
Your witness must be of age the same way that you must be of age.
And then you have to make sure they're right in their head and they're not, they're not likely to die before you.
But I mean, as a younger person, there's nothing wrong in having someone around your age. But what you may find as you get older, you may consider redoing it. So that you have younger witnesses, right? But I understand that, hey, if your witnesses died, there are provisions for how you get around showing that it was executed, but it's a little more challenging.
All of that we're doing in part 2. I mean, part 3 really, yeah. I think you're coming to part 2 before, so it's a part 3 because listen, I have plenty questions. We might take over all of the rest of the weeks coming here with your voice. Kern Edwards, attorney at law. Let me thank you very, very much for this enlightening episode that now have me wondering if I need to go and handle my own business. All right. So thank you.
If you haven't, certainly go and do.
Yeah. Thank you very much. We've had this conversation so that whenever you listen to this podcast episode, you will be able to handle your business.
Handle Your Business, a weekly podcast discussing a little of this and a little of that. Handle Your Business appropriately blends serious topics with fun topics, all in an effort to help you have a good or better life. So join me, your host, Lady Lashley, and some amazing guests every Sunday at 5 p.m. to explore everything from financial management to dealing with relationship challenges. Put it in your calendar every Sunday from 5 p.m. Tune in to Handle Your Business to get you ready for the week ahead. For more details, follow at Lady Lashley TT on Instagram and Facebook. Handle Your Business.